Greetings and welcome to today's webinar, FMLA Understood, Frequent Mistakes to Legally Avoid, presented by Quarles and Brady. My name is Sean Scullin, and I serve as the firm's National Chair of the Labor and Employment Group, as well as co-chair of the firm's Class Action Subgroup. I work with both private and public sector employers in a multitude of labor and employment law matters, including federal and state Family and Medical Leave Act compliance, multi-jurisdictional defense of litigation and employment discrimination, and whistleblower matters, as well as collective and class action wage and hour matters. I'm co-presenting today's webinar with my colleague, Lindsay Davis. Lindsay similarly works with employers of all sizes across a wide range of industries, providing clients with practical counsel and solutions to their employment-related needs, including issues involving counseling, discipline, and discharge of employees, as well as compliance issues. Lindsay has extensive experience in the areas of disability and Family and Medical Leave Act compliance in particular, and frequently provides in-house training to clients on such issues. A few housekeeping items to go over before we begin the presentation. We will be applying for 1 hour of CLE credit. If you're an attorney and would like to receive CLE credit for attending today's program, please fill out the CLE form located at the back of the materials found in the handouts panel of the webinar dashboard. Please complete the form and return it to the contact listed at the bottom of the document. There's also an HR attendance certification form in the dashboard materials for human resources professionals to use in self-reporting. We have muted all phone lines for those dialing in and for participants listening to audio via computer, so you will not be able to speak. We are in listen-only mode. We would like you to be aware that this presentation is being recorded and an electronic survey will be emailed to you after the program. If any webinar participants have a question, please type your question in the chat box located in the upper right corner of the webinar dashboard and click submit. We'll make every effort to answer as many questions as we can near the end of our time together today. If we don't get to all the questions, we will have a record of who has asked what, and we'll be able to follow up accordingly. Now let's begin. First, let's talk about our agenda this morning. We're going to start with a quick FMLA refresher, and then we're going to get into tackling frequent and frequently difficult leave issues, including banking FMLA leave, notice of absence, recertification, working while on leave, addiction issues, both related to alcoholism and drug use or drug addiction, and then finally handling suspected FMLA abuse. With that, I'm going to turn it over to Lindsay.
Good morning or afternoon, everyone. I like to say that when you are faced with a potential FMLA question, one of your employees has indicated a potential need for leave, there's sort of a specific few steps that you want to follow in every single instance. The first is that you should always be asking whether you are a covered employer. Now, we assume that if you're participating in today's presentation about the federal FMLA, you are probably a covered employer or will soon be, but it never hurts to go over these basic requirements. So as to the covered employer, you are covered under the FMLA if you, in the private sector, employ 50 or more employees for at least 20 work weeks in the current or the preceding calendar year. You should always also be asking in every instance whether the employee who has come to you is eligible for federal FMLA leave. Eligibility under the federal FMLA leave means that the employee must have worked for at least 12 months. And remember, there could be a break in employment. So what we're looking for is a cumulative 12 months with you as the employer. You also want to look at how many hours has the employee worked in the past 12 months. The number you want to hit here is 1,250 hours for eligibility for federal FMLA leave. And finally, you'll want to look at whether the employee works at a location where the employer, you employ at least 50 individuals within 75 miles of the work site. The important date for purposes of looking at that number is the date that the employee gives notice of the need for leave. So once you become aware of the need for leave, you should look at what work site does this employee work out of? Do we have at least 50 employees at that work site or within 75 miles of it? Note as well that this analysis still applies even when you're talking about remote workers. And in the case of remote workers, you want to look at what is the work site that they report into, and does that facility have at least 50 employees? So let's say that you pass those two sort of who's covered and who's eligible tests. The next thing you want to be asking yourself is, okay, what am I required to provide if I'm a covered employee working with an eligible employee? And the basics is that you're required under the federal FMLA to provide 12 work weeks of leave in a 12-month period. Employees are eligible for this 12 work weeks of leave for the birth or placement of a child, for adoption or foster care, for their own serious health condition, or to care for a spouse, son, daughter, or parent who has a serious health condition. Employees are also eligible for leave under the FMLA for qualifying exigencies involving covered family members who are in the military. In addition, under the FMLA, you're required to continue the benefits that the employee is receiving prior to the request for leave. So if the employee is receiving health insurance, their health insurance should continue throughout the leave period as long as they continue to pay their portion of the premium. Once an employee has completed their 12 work weeks of leave, you are also required to return them to an equivalent position absent sort of extenuating or unusual circumstances. And finally, while the employee is on leave, employers are prohibited from interfering with the employee's right to take the leave of absence, and also from retaliating against an employee who exercises their right to take federal FMLA leave. We also want to cover just at a high level, what is a serious health condition? Remember that employees are entitled to leave if they have their own serious health condition or to care for an immediate family member with a serious health condition. Basically, a serious health condition is an illness, injury, impairment, or physical or mental condition that either involves inpatient care or continuing treatment. You'll see in the materials that we've further defined what constitutes both inpatient care and continuing treatment. When you're looking at inpatient care, what you're looking for is an overnight stay in a hospital, hospice, or residential medical facility. And you're looking for a period of incapacity or any subsequent treatment in connection with that overnight stay. An employee can demonstrate continuing treatment in a number of different ways, again, which are bullet pointed on this slide here. But you'll see that you're looking for either incapacity plus treatment, pregnancy, a chronic condition, a permanent or long-term condition, or a condition that requires multiple treatments over time. So with those basics out of the way, what Sean and I want to do now is tackle those frequent and frequently difficult FMLA issues that we are pretty regularly getting calls about from the clients that we serve. And the first one we're going to tackle is on the issue of banking FMLA leave. And for that, let's look at the scenario involving Deborah and her elderly father. Deborah's father has a serious fall that results in a lengthy hospitalization. Deborah wants to spend a week with him, but she doesn't want to use FMLA given her son's upcoming surgery and her own pregnancy. She tells her supervisor that she'd like to take a personal leave of absence rather than FMLA leave. Her supervisor tells Deborah that while she can have the time off if she produces the documentation supporting the request, it is going to count as FMLA. Deborah insists that her supervisor cannot make her take FMLA if she chooses not to. Is Deborah right? Let's take a look at the rules that apply in this scenario. First, straight out of the FMLA regulations, we know that once an employer has acquired knowledge that the leave is being taken for an FMLA qualifying reason, the employer must designate the absence as FMLA. In addition, we have opinion letters from the Department of Labor that address this topic as well. The first one indicates that employers may may designate and advise employees that an absence is going to count against the employee's 12-week entitlement to FMLA leave, even if the employee has not requested that it be counted as FMLA leave. In addition, we know that employers may not treat more than 12 weeks of time off as FMLA qualifying during one FMLA year. So if we go back to the scenario involving Deborah, here we know that Deborah's leave of absence that she has requested is one which implicates the FMLA. Specifically, Deborah's father has had a serious fall, and we know that's resulted in a lengthy hospitalization. So that's a serious condition involving inpatient care. Since Deborah has put us on notice that the leave of absence is one that is FMLA qualifying, as an employer, we're required under the FMLA regulations to count that leave of absence as FMLA. So what are the practical tips to deal with when we are confronting an issue where an employee is indicating the potential need for leave? Well, first, we generally recommend that an employer take a leave, that when an employee takes a leave for an FMLA qualifying condition, you designate that leave as FMLA. Not only is that what is required by the regulations, but there are additional benefits to following that approach as well. It avoids you having to try to guess the employee's intent in notifying you that they have a serious health condition or a relative with a serious health condition and needs some time off of work. Is the employee indicating a need for FMLA leave, or are they just indicating some other desire to take a different type of leave? You don't have to play that guessing game if you automatically designate the leave as FMLA qualifying. In addition, once designated as FMLA leave, the employee's job is protected under the federal law, and you avoid a situation in which the employee is trying to stack various types or various versions of leaves of absence and ultimately taking quite a significant time off of work. In addition to that practical tip, we also recommend that you consider which leaves run concurrently and, as permitted by your state's law, run leaves concurrently. So you should be basically counting a particular leave of absence under both federal and state FMLA allotments, so long as the law permits it. Same is true with workers' compensation leave and FMLA, as well as paid sick leave and FMLA. And with that, I'm going to turn it back to Sean.
The only other point I think I would make on that is to follow up on the last point Lindsay made, which is I think you can't assume that if you are subject to a state law that the state FMLA is necessarily going to follow the federal designation rules. And there may in fact be states in which under the state rules, if an employee does not want to have the time treated as FMLA under that state law, the employee may be allowed to refuse the employer that designation, and therefore the employer is in the difficult position of having to track those leaves under the differing federal and state laws. But just something to keep in mind, always ensure that you're checking with state law compliance if the employee is in a state where they are subject to a state family medical leave law. Okay, second frequent issue, notice or lack thereof of an FMLA absence. So in our next hypothetical here, we have Penny, who's a paramedic at Helping Hands Hospital. Penny has requested intermittent FMLA for flare-ups related to a tremor she's developed. Under HHS's policy, Penny was required to submit her request to the company's leave administrator, Aon Hewitt, and report FMLA-related absences to her supervisor according to HHS's attendance policy as well as to Aon. Penny missed several days of work. She did inform her supervisor she was not going to be reporting to work because she was sick or hurt her neck. However, Penny did not contact Aon regarding her absences. Subsequently, HHS discharged Penny after she accrued several seemingly non-FMLA absences in violation of their attendance policy. Following her discharge, Penny asserted an FMLA claim, alleging that a number of her absences were in fact FMLA protected. While admitting she had never contacted Aon, Penny contended that she had contacted her supervisor and, as the FMLA provides elsewhere, once an employer is on notice that FMLA leave may be taken, it has the burden to seek further information regarding said leave. Who's got it right here? Well, HHH is probably in the better position here. Generally, an employer may require that employees comply with the employer's usual and customary policies for requesting leave. As the Sixth Circuit Court of Appeals found in the Perry versus American Red Cross case, that means that the employer can include a requirement that the employee call a designated number or an administrator when utilizing FMLA leave. Now, the one thing that employers have to keep in mind is that if there are unusual circumstances that prevent the employee from following customary call-off procedures, then the employer can't assess points or issue discipline. So, for example, an employee can't receive points under a no-fault attendance policy for failure to call off before a shift, where it's the FMLA qualifying condition that makes it impossible for the employee to do so. So a couple of practical tips regarding notice requirements. Call-off procedures really do remain an effective tool that employers can use to manage individuals on FMLA leave. Many clients have, as part of their attendance or other policies, requirements that, for example, employees give at least 30 minutes or an hour's notice if they're not going to be present for their scheduled shift. And the only caveat here, particularly if someone is on FMLA leave, is ensuring that, you know, and we see this frequently where somebody on FMLA ultimately calls in and reports the absence during their shift, but violates that pre-shift call-in rule. And as we discussed, the previous case law and the regulations make clear that the employer can enforce those rules so long as the employee does not have an argument that their condition is what caused them to be unable to meet the call-in requirement. So a couple of you know, practical tips there. The first is that we need to ensure that the enforcement is consistent. We sometimes see inconsistent enforcement. We see the supervisors who are holding the people who are frequent FMLA and especially FMLA intermittent users to perhaps a higher standard, but letting it slide when other employees call in but don't comply with the call-in requirements. So there needs to be consistency, otherwise an employee who's utilizing FMLA leave is going to be able to successfully argue that that selective enforcement gives rise to a valid FMLA retaliation claim. And the last practical point, as noted, is that there's probably a follow-up question that, as the employer, you need to confirm that when you investigate the employees who is using FMLA on a particular day who has failed to meet the call-in requirements, be sure you are asking them at the outset whether there is some reason, you know, what the reason was that they failed to call in. I think you want to know that at the outset before you're assessing points and potentially disciplining and potentially even terminating somebody who has been assessed points or otherwise violated the attendance policy because they're not complying with your call-in procedures. Much better to know now than 6 months, 9 months from now when they've talked to an attorney and we're in litigation and we're finding out for the first time that they're coming up with some excuse related to their FMLA condition as to why they failed to meet the notice requirements.
So Sean, based on the rules that you've provided, if we go back to the example of Penny, the paramedic at Triple H, I think where we would land on that one is that Penny did fail to follow the call-in procedure, specifically in not contacting Aon Hewitt. And because it doesn't appear that any unusual circumstances prevented her from doing so, assuming that Triple H has been consistent in enforcing its call-off procedures, I think there's a good argument that they could do so with regard to Penny as well.
Agreed.
Okay, so let's move on to the next hypothetical. This one dealing with the issue about whether to recertify or not recertify when you've got an employee who's on an FMLA leave of absence. And for this particular example, we're going to talk about Layla and her employment at Safari Inc. So Safari Inc. is an online retailer that guarantees delivery of purchased items within 24 hours. Layla's position at Safari Inc. is as a delivery driver. Given Safari's delivery guarantee, employee attendance is essential to the company's operations. Layla has suffered an injury to her back while playing in a recreational softball game, and she has requested FMLA leave for back pain. She submitted a complete and adequate healthcare provider certification, which indicates the need for intermittent leave for flare-ups and identifies an expected frequency of those flare-ups of 1 to 2 times per month. The expected duration of Layla's back pain is 2 months. So Safari grants Layla's request for intermittent leave after confirming that she is eligible under the federal law. And over the next 2 months, Safari observes that Layla takes intermittent leave more than was anticipated in that original healthcare certification form. Specifically, during month 1, she is out for 4 instances of intermittent leave, and during month 2, she is out 6 times. At the conclusion of the 2-month period, Layla requests to extend her intermittent FMLA leave by an additional 2 months. Safari is concerned about the frequency of Layla's flare-ups, which seem to occur on Mondays or Fridays, and are inconsistent with the healthcare provider's initial predictions. So the question is whether Safari can take any action based on its concerns. Is it required to extend Layla's request for FMLA leave? Let's take a look at the rules, and then we can come back to this scenario. So the regulations under the FMLA get very specific as to recertification and when it is or is not permitted. Basically, unless there are changed or suspicious circumstances, the following general rules apply. First, employers may request recertification anytime an employee seeks to extend an existing FMLA leave. Second, employers may request recertification up to every 30 days in connection with an absence for long-term conditions or conditions that may require sporadic intermittent absences. The third rule is that if an employee is on an FMLA leave that has been certified to extend more than 6 months, then the employer may seek recertification every 6 months. And fourth, an employer may ask for a new certification at the beginning of each FMLA leave year, but this request must be made in connection with a new absence in the new FMLA year. In addition to these 4 general rules, there are also rules governing the circumstances changing or you receiving information that casts doubt on the validity of an employee's request for FMLA leave. So basically, you can throw that 30-day rule out the window if the circumstances described by a previous certification have changed significantly, or you receive information that casts doubt on the employee's stated reason for their absence or the continuing validity of the existing medical certification. In either of those 2 instances, you are allowed to request a recertification, even if 30 days have not passed since you last received a certification from the employee. And finally, want to make clear what you can ask for and what timelines apply. So with regard to what information you can seek as part of the recertification process, the general rule is it's the same information as permitted in the initial medical certification. And with regard to how much time the employee should be provided to return the recertification, again, generally 15 calendar days after the request is made. If, however, the employee indicates some circumstances that have prevented them from meeting the 15 calendar day deadline, you should seriously consider extending that deadline. Okay, so then if we go back to our circumstances involving Layla, based on the rules that we've just reviewed, I would say that it is appropriate to seek a recertification. And really that could be for 2 different reasons. First of all, Layla has requested an extension of her intermittent FMLA leave. And as we know from the regulations, that extension request triggers a right of the employer to seek a recertification. But perhaps more importantly than that, our fact pattern here also lays out circumstances which I would characterize as being suspicious and as being a sort of deviation from the anticipated frequency of the intermittent leave based on the healthcare certification the employer initially received. So in this instance, we have the two facts. One, Layla's intermittent leaves of absence are greater than what was anticipated by her healthcare provider, and not in a minor way, right? By month 2, she's really almost tripled what was the anticipated frequency of her intermittent absences. In addition to that, over the 2-month period, we are picking up on a pattern, a Monday-Friday pattern. And both of those facts, I think, are ones that suggest a significant change or deviation from the original healthcare provider certification and warrant you getting additional information before approving the extension request. This is an instance where I would seriously consider providing the healthcare provider with information about the pattern you're observing and the increased frequency and requesting an explanation for those changes. Okay. I'm going to flip it back to Sean to talk about addiction issues.
Yeah, and I think one other point that's useful to keep in mind is, I think both our experience is probably that unfortunately for the people who are abusing it and have a Monday, Friday pattern, we're unlikely to get back from a healthcare provider a clear response that the person's abusing and it's not consistent. But sometimes when confronted with their attendance record, the healthcare provider will say that it's not necessarily, and there's no reason why it should necessarily be following that type of pattern. Even if they don't, however, I think it is useful as a practical matter to let those employees know who we think may be abusing, that we are watching it and that we're not simply going to be passive about it because, as you know, everybody else, all of their coworkers are watching that as well. And oftentimes, even though we don't get a particularly helpful response on recertification for the healthcare provider, the fact that the employee knows that we know and that we are watching it closely does cause a reduction going forward in the amount of times that they're using it in a questionable or problematic pattern.
Mm-hmm.
Okay, so next let's talk about issues related to accommodating alcoholism. Our hypo here is that we've got a lead, Leon, who works in the R&D department for Symphony Sand. Lately, Symphony's plant managers have noticed some deficiencies in his work performance. He uncharacteristically missed a scheduled safety meeting and has to be repeatedly reminded of internal deadlines. One day, as she's walking past Leon's office, plant manager Pam observes Leon take a bottle of scotch from his bottom drawer and pour a healthy serving into a coffee mug. The company's policies prohibit the use of alcohol in the office during working hours. As a result, Pam approaches Leon regarding his deficient performance issues and her observation of him drinking while at work. During their conversation, Leon acknowledges he's battling alcoholism. He notes that his drinking is impacting him both at work and at home, referencing notable withdrawal symptoms when he refrains from drinking. He states he's been seeing a psychiatrist and he's been diagnosed as an alcoholic. Leon's psychiatrist is recommending that Leon participate in a rehabilitation program, and Leon requests time off work to do so. Should Symphony grant Leon's request? Should Symphony discipline Leon for his work performance? All right, well, again, let's look at the FMLA rules as they relate to alcoholism. Under the FMLA, an employee is clearly entitled to leave related to alcoholism only if he or she is requesting the leave for the purpose of seeking and obtaining treatment for the condition or to care for a relative who's seeking or obtaining treatment. However, if the employee misses work as a result of the alcoholism itself, meaning the employee has to sleep one off or chooses to take the day off to drink, rather than treatment, that time off clearly does not qualify for FMLA, nor does a request for leave require the employer to ignore violations such as drinking at work. So I think going back to our example here, should they grant Leon's request? I mean, they might if they want to be overly generous. I don't think the FMLA requires them to do so because, as we noted, the rules do not require the employer to overlook the impact of the drinking at work, as well as the violation of having been observed drinking at work. And I think, you know, this not only raises obviously FMLA issues, but also ADA and state disability accommodation issues. And the rules there are very similar. And, you know, where there may be some issues, this is sort of another example of sort of a second chance where somebody first raises their disability, which alcoholism itself would be, raises that sort of in a termination meeting. And at least the federal courts have been pretty clear that employers don't necessarily need to give sort of an after the fact second chance to people who first raise their disability at the point of termination. But note that that may not be the case in all of the states in which you have employees. So you also need to closely look at both state medical leave laws and disability discrimination laws. So another sort of common and related issue is accommodating drug addiction. So in this scenario, we've got Steve, who for the past 11 years has worked at a large company, during which time he's risen through the ranks. Steve is a good employee who routinely receives positive performance evaluations. Steve is in a supervisory role, which is also outward facing to customers. He has regular contact with company customers to discuss quality issues and new product development. Steve takes a 1-week vacation and while away from the office is arrested for possession of cocaine. When he returns to work, he informs his boss of the arrest. Steve acknowledges recreational use of cocaine, but denies ever using the drug at work and denies any form of drug addiction. Steve has exhausted all PTO who has exhausted all PTO for the year, requests an additional 2 weeks off to meet with his lawyer and attend court appearances. What are the company's obligations under the law, if any? And if the company denies Steve's request and he takes the time off work anyway, can and should the company discipline Steve for his absences? All right, let's talk about the applicable rules. So as with alcoholism, FMLA may be taken for treatment for substance abuse by a healthcare provider. However, absences that are a result of the use of a substance rather than for treatment are not covered under the FMLA. Similarly, the ADA and state disability discrimination laws are going to apply here. As we discussed with alcoholism, an employee's current use of illegal drugs is not protected, although an employee's history of addiction can be protected under the ADA's safe harbor provisions. So I think, what does this mean for Steve? And there's another sort of aspect here, which is Steve may be in a state like Wisconsin, which has arrest and conviction record statutes. And the question might be, well, even if we're inclined to give him this leave, can we terminate Steve because he now has a public arrest for possession of cocaine, and we're concerned about how that's going to look to some of our customers. I think under some states, whether that would be substantially related to Steve's job here, I think was probably a stretch. That may be a hard argument to make, and whether the circumstances of the possession of the drugs would suggest that his job is one where he would necessarily be likely to reoffend, I think is probably a hard discussion. We don't have to. Steve isn't asking for time off to get treatment. He's asking for time off to deal with his legal issues as a result of his arrest. That's time that we don't have to provide either under the FMLA or disability discrimination law. And as long as you are consistent with treating time off for arrest or incarceration, and assuming he's otherwise, as the hypothetical here suggests, exhausted all of his leave, you don't have any obligation to accommodate that. And as a result, we can indeed discipline him for his absences if he takes the time off without authority to meet with his lawyers, attend court appearances, and or because he is incarcerated as a result of his legal issues. So practical tips for handling employee drug and alcohol use: put in place and adhere to policies prohibiting employee drug and alcohol use. As we mentioned, be familiar with state laws that may come into play, arrest, conviction, record discrimination issues, lawful use of some certain controlled substances. Obviously here we're talking about cocaine, which at least currently isn't authorized as legal anywhere in the US, but of course, marijuana is, and increasingly state by state, we're seeing laws which make possession and use permissible. The employment laws have been slow to catch up. We're just seeing the start of states passing laws which make it illegal for employers as a matter of state law to take action against employees who test positive, for example, for marijuana use. Which creates all sorts of problems because, as we sit here today, testing does not show current impairment, unlike alcohol or some other drug tests. It typically tends to just show historical use within the last 30 days or so. Be familiar with employee assistance offerings, and practice consistency in implementing discipline. One final sort of practical tip here to keep in mind: there is some uncertainty in the courts as to the compensability of time when an employer mandates that employees seek certain treatment. So, for example, the Seventh Circuit Court of Appeals, which decides federal law for Wisconsin, upheld an employee's claim that the employee was entitled to compensation for the time that the employee was required to spend as part of a mandatory EAP referral in treatment. Since then, there have been a few other cases where courts have rejected the notion that, for example, employees who tested positive for drug or alcohol use and had a rehabilitation obligation, that the time they spent complying with that condition of their either continued employment or reinstatement, that time was compensable. The cases are highly fact intensive, and it depends on how much the employer is involved in setting the conditions of the treatment. So it's important when writing those either final warnings or those last chance agreements to keep the wage and hour compensability issues in mind as well.
Okay, let's switch gears then to what is our final hypothetical scenario in today's presentation, and then we'll get to the questions that we've received from the audience. I'll just make a plug as well. If you have a question that we haven't yet addressed, please feel free to submit it via the option that Sean talked about at the beginning of this webinar, and we are happy to review it and provide a response to you. Okay, so our final hypothetical here deals with what I would probably say is one of the more common or most common FMLA questions that I get when I pick up my phone and respond to a client call. This deals with the issue of, I've heard through the rumor mill, or I've seen on Facebook, or I have employees reporting to me that an employee who's out on an FMLA leave of absence doesn't appear to be spending that time in recovery or recuperation or caring for a loved one. So to illustrate this point, let's talk about Carla. Carla is a counselor at West High School, and 2 weeks ago she requested FMLA leave and provided her HR manager, Mark, with a medical certification form from her primary care physician. According to the certification form, Carla is completely incapacitated and unable to work because she was recently involved in a car accident and severely injured her back and her right shoulder. Carla's physician indicates that she should remain off of work for 6 weeks. 2 weeks after approving Carla's FMLA request, Mark is watching the Brewers game on TV. When Ryan Braun hits a home run into the crowd, Mark sees Carla jump into the air, arms extended, to catch the fly ball. During the same week, Larry, who is one of Carla's coworkers and follows Carla on Instagram, shows Mark a few of Carla's most recent Instagram posts. In one, captioned #moving-day, Carla and her husband are standing side by side, each holding 2 cardboard boxes. In a second, Carla is kayaking with her husband down the Wisconsin River. Carla has captioned this photo #vacationing. Based on this evidence, Mark suspects that Carla is not completely incapacitated as the result of her car accident. Mark wants to revoke Carla's FMLA leave and fire her for violating the school's attendance policy. Can Mark take these steps? If yes, is there anything additional that Mark should consider before moving forward with his plan? So let's talk about the rules here. First of all, I want all of you on the webinar here today to know that the law does support an employer's right to discipline an employee for actual FMLA abuse. To me, one of the sort of best cases illustrating this point is a case called Fitterer out of the Eastern District of Washington. Basically, in that case, the court found that an employee's failure to present any evidence that she was incapacitated from work during a 2-week period that she was on board a cruise ship resulted in dismissal of her FMLA interference claim. Fitterer was a very bold employee. She worked as a job services specialist for the state of Washington. During her employment, she suffered from migraine headaches and was granted intermittent FMLA leave as a result of that. What happened with Fitterer is that she then submitted a doctor's note which excused her from work for a 2-week FMLA vacation, presumably relating to her migraine headache condition. And while she was away, her stepfather came into the office, and when her supervisor asked whether Fitterer was doing okay, her stepfather responded, "Oh yeah, her and her husband are on a cruise." Understandably, the employer in that particular situation was not pleased, and they did take the step of terminating Fitterer's employment upon becoming aware of these circumstances. The employee in that case did file an FMLA interference claim, but as I noted at the outset, the court was not sympathetic toward her, particularly because she couldn't present any evidence that suggested she couldn't have worked during the 2-week period that she took an FMLA vacation. On the flip side of that, though, it's important that you know that even these vacations can, in some circumstances, constitute FMLA covered leave. So for that, we like to point to the example of a case called Ballard versus Chicago Park District. This is one in which the employee accompanied her mother to Las Vegas, and she requested FMLA leave to cover her trip to Vegas, contending that she was going to be caring for her mother during that time, and if she can care for her mother at home, why should it be any different when she's in Vegas? And in this case, the court was sympathetic to the employee's position, ultimately denying the employer's motion for summary judgment, where the evidence suggested that during the trip to Vegas, the employee was providing care to her mother, who had an FMLA-covered serious health condition. So although there was also evidence that the employee was playing the slots and shopping, because she was actually providing care for her mother who suffered from a serious health condition, the court said, we think there is at least potentially a valid FMLA claim here. So where does that leave us with regard to Carla? I think here again, we have some evidence that seems to suggest that Carla is abusing her FMLA leave. In particular, we know from the healthcare certification form that Carla is completely incapacitated and that her injury was to her back and her right shoulder. It would seem inconsistent then that Carla is able to jump into the air to catch a fly ball and to carry potentially heavy cardboard boxes during a move and paddle down the Wisconsin River during a vacation, all when she is presumably meant to be recovering from the injury that she has suffered. So what would I suggest that Mark do in that case? Well, I think that brings us to the practical tips that we've identified for confronting suspected abuse. First and foremost, as I'm sure most, if not all of you do, you should require a written leave request when an employee indicates a need for leave. And as part of that written leave request, you should obtain a healthcare certification form. The form is going to become important because it identifies the contours of the serious health condition and why there is a need for the leave and what form the leave should manifest in. So when you receive evidence that an employee may be abusing their FMLA leave, go back and take a look at that certification. You should always be looking at the certification for completeness. If you feel it's incomplete in some way, it's appropriate under the FMLA regulations to follow up with the employee or the healthcare provider. Look at the certification form to determine what limitations the doctor has identified, and then consider whether those limitations are inconsistent with what you know the employee to have been doing during their time away from work. You should also be thinking about whether the circumstances that you have since become aware of make a request for recertification appropriate. Finally, we recommend that you meet with the employee regarding the leave request. I think it is potentially risky to take the step of terminating an employee for FMLA abuse before talking with them about the information that has come to your attention and getting an explanation from the employee about what they've been doing on their time away from work. So gather what information you can, from coworkers who have come to you, from your review of public social media posts, and then bring that information to the attention of the employee and ask what they were doing during their time away from work. If you don't get a satisfactory explanation, that is when it's appropriate to consider disciplinary action. In addition to that, you should confirm, I would recommend at the start of a leave that an employee understands that if condition or if there have been changes in his or her conditions or work restrictions, they do have an obligation to inform you as the employer. We have seen and probably will continue to see circumstances in which an employee says, oh yeah, I was able to go to the baseball game because I have had some improvement in my condition. My doctor is now saying I'm able to, extend my arm upward, although I still can't lift more than 50 pounds. And those changed circumstances may mean that attendance at the baseball game is not actually inconsistent with the FMLA leave, but of course you don't have that information unless the employee is supplying it or you seek a recertification. So with that,
I guess just a couple of follow-up comments on that. As Lindsay said, I think this is one of the most common questions that we get, and I think particularly with the advent of social media and everyone posting everything they're doing in their lives without giving much thought, obviously in many circumstances, as to how that might look. A couple of things. I think one, the courts recognize as well that somebody may be able to attend. There's one thing if their FMLA says they're completely incapacitated, but the courts and doctors, the healthcare providers who are certifying the time off from work, often recognize that somebody may be able to attend a baseball game for a couple of hours or engage in some activity that looks like a leisure activity or even a physical activity. But that doesn't necessarily mean that they're able to work, in their job, which may require lifting or for a full 8 hours. So I think that also goes to Lindsay's point about, well, if they can, do it for 2 hours, should they only be on sort of intermittent leave? Mm-hmm. But I think there is people's visceral reaction to images that they see, and especially when coworkers are seeing it who are, back at work, sort of picking up the slack from somebody being off. There is sort of a balance there. Although the appropriate thing is to sort of confront people and get clarification on exactly what their limitations are. We often see that as well with regard to employees who may be working a second job, and it's while they're on FMLA leave from your employment. And again, the courts have recognized that there's not necessarily something inconsistent with somebody working at a different job to the extent that their FMLA condition keeps them from working working at the job for you, although potentially not for their other employer. And I guess lastly, the obvious red flag should go off, and I've had a number of these issues, is when somebody requests time off, it gets denied for some reason, and then they subsequently use FMLA leave to get the same time off. That's an obvious red flag. That's usually a case of abuse, and oftentimes it's relatively easy to establish. I think the most recent case I had was where somebody went to France, and then they did seek medical treatment in France, but when we asked them to produce their travel records, it showed that they had booked the return flight for several weeks in advance, and they really had no intention of returning, and therefore the FMLA leave was denied, and ultimately the employee was terminated. So another common sort of red flag and something to keep in mind. I guess with that, we'll turn it over to and go through some of your questions.
Yes, and credit to our great audience today because we've gotten a number of really good questions. We'll try to cover as many as we can. So Sean, one of the first questions we got here is, what would you recommend as the best practice for confronting the Friday-Monday pattern with regard to intermittent FMLA leave?
Yeah, so I think, and often we do see clear patterns. You can look at somebody's attendance over the past, several months, and the only absences, if their certification says they'll need, a day off every, several weeks, and the only time they take off is a Friday or a Monday, and they're working a Monday through Friday schedule. I think the best way to confront it is to tell them that you're going to confront their doctor about it and follow up with a recertification, in which what you do is send essentially a letter to the healthcare provider providing the attendance records saying, your certification simply says that they'll need, a certain time off. But every time that they use the leave, it's on a Monday and Friday, this doesn't appear to be consistent with your certification. And as I said, what we see, sometimes we'll get particularly helpful responses from the healthcare provider. Not always, but the practical benefit of that is it shows the employee that you are watching what they're doing, and oftentimes it will result in prospectively their second thinking, sort of blatantly abusing their time off, and they may be more reticent to use the time to extend weekends.
Mm-hmm. Okay, let's take another one here. We got the question, if an employee is home sick with a cold for 3 or more days, this would not be considered a serious health condition and would not qualify for FMLA. Is that a correct statement? And the lawyers in the room are going to say, most likely, yes, that's a correct statement, but it is going to depend. Generally speaking, under the FMLA, a cold is not going to rise to the level of a serious health condition that entitles an employee to federal FMLA, but I think you still want to do the analysis there. So this is most likely going to fall under the category of potentially incapacity plus treatment. And what you're looking for there is more than 3 consecutive full calendar days of absence plus subsequent or continuing treatment. So did the employee seek medical care or attention during the time that they were away from work? Just having 3 days of absence is not going to be enough, so you need to get to more than 3 consecutive days, and then be following up with the employee to understand whether they've been receiving treatment. You should also always be looking at whether this condition is resulting in incapacity under the FMLA, which means either an inability to work or to perform another essential function, such as attending school, performing regular daily activities as the result of a serious health condition. So I think a good general rule is usually a cold is not going to cut it, but you should be looking closely at the circumstances and doing that analysis on a case-by-case basis. Okay, another one here. If an employee is taking time off frequently and you have suggested FMLA and provided them with paperwork for the doctor, but the employee chooses not to return the paperwork or doesn't want to pay the potential expenses of, seeing a doctor and getting the paperwork completed, how should you handle that?
I think you hold people to the certification requirement, and I would treat, this is a little bit different than designating because something is FMLA time. Here we don't have clear evidence that in fact it is FMLA time, and so the regulations make very clear, the law makes very clear, and courts have upheld the discipline and termination of employees who don't provide the required certifications on a timely basis, generally within the 15-day period, or extended if they've got a legitimate, reason for needing additional time. And I think Lindsay and my practice is always to generally give employees some additional time, especially at the first request. But I think if they have not provided the certification for, whatever reason, then you treat it like an unexcused absence and treat them accordingly under your attendance policy.
Another question we've gotten is an employer required to pay holiday pay for an employee who is on an FMLA leave of absence, an intermittent FMLA leave of absence? The answer there, again, under the regulations, is that it depends. And in this case, what it depends upon is whether you have an established policy for providing such benefits, and do you, under your policy, provide holiday pay to other employees who are on other forms of leave. So for instance, if you have an employee who's taken a non-medical leave of absence, do your policies provide that that employee will continue to receive holiday pay? If so, then you should also be giving holiday pay to the employee who is out on an FMLA leave of absence.
Another question we have is, are you seeing an increase in clients using the second opinion option for employees who you believe are abusing FMLA? I'm really not. I generally think, and I think Lindsay and I have certainly talked about this and others, we don't think it's a great mechanism, because ultimately what it means is probably a lot of time and expense for not a lot of benefit. At the best case scenario under the second opinion sort of option is that you come out with conflicting healthcare provider opinions, and you're sort of left with, well, that's what it is, and you may have to simply litigate it sort of down the road. I think both of us and others here would say your better option is to stay on top of both the employee and their healthcare provider with regard to any inconsistencies related to potential abuse of FMLA.
We got a question relating to recertification, specifically if an employee is taking time off for a physical therapy not related. Oops, I'm reading the wrong question. If you've got an employee who has provided a certification that covers a 6-month leave of absence, can you still recertify with the first absence of the new FMLA year, even if it's within that first certification 6-month period? And the answer to that question is yes. Under the FMLA regulations, so long as it's connected with an absence, when you get into a new FMLA year, you can request a new certification. We've got time probably for one more.
Yeah. Is there a limit as to how far back the 12 months goes as far as qualifying for FMLA? We rehire a lot of employees in our industry, so the answer is no. If somebody has worked for you for a total of 12 months, and maybe they worked for you for 10 months previously, or even 12 months, and then they've been employed with you only they left and came back after 5 or 6 years, and they've worked 1,250 hours, even though they've only worked, for example, 7 months during the year, they will qualify for FMLA leave under the federal leave law.
Okay, so we are at about time right now, and we want to be respectful of your calendars and your busy schedules. If we didn't get to your question, again, we've maintained a record of them. We'll take a look at them, and we encourage you to follow up with us if you'd like to discuss any of these topics further. Otherwise, we thank you for your time and for your participation in today's presentation, and hope that you have a good rest of the day.
Thanks, everyone.